Honorable Milham's questions, I think, who should pay, hence the matter is taken to Concord. That will be dealt with there to clarify the matter. And indeed, I'm before the committee, I'm accounting to Parliament. This process is the first of its kind. I think that has been repeated several times. There was never a process like this. It's a learning curve for everyone. And whatever we are doing here, it's for future generations, and how the heads of Chapter 9 institutions will be dealt with when there is a process like this. So the Constitutional Court will have to then, because the Parliament seems to be second guessing their judgment, so they have to clarify that matter for everyone. And unfortunately, if you say it was a pause button and not a new process, unfortunately, there are letters which will be shared or which are shared with this committee. Letter from the CEO, the accounting officer of the institution, indicating that they don't have the monies. And if you say to an appointed attorney, there's no money to proceed beyond 81 March, I don't know what does that mean. But then again, hence I said to you, I'm not involved in that. I'm not the accounting officer. And Honorable Nkosi, I don't know when you say the 4 million is enough. Indeed, yes, going back to the institution. Originally, there was an agreement with the legal team, and there were negotiated rates, and we wrote the letter to the Deputy Public Protector where I clarified that even Advocate Mpofu's rates and even the other legal team, they were negotiated rates which were even below the normal rates which they were charging at the particular time. So there was that agreement, which was done by the CEO as the accounting officer. I was never involved in that particular process, and with the attorney engaging the legal counsel. So I think whilst at the 4 million, Honorable Maneli, I don't know when you say that has been negotiated or agreed to with who, and how did they come to realize that the 4 million, including myself, I don't know, Honorable Nkosi and Maneli, whether you have practiced in the past and you know that the evidence which is before the committee, the money is sufficient for the legal team to proceed. I can't comment on that. So I think what you are saying, that indeed adjourn the meeting, which I will have to engage and request the CEO to deal with this matter. And there is a panel of attorneys. They are the ones who should be going back and say, on the panel of attorneys, Public Protector, are you still willing to proceed with Sianeho, which is was my attorney of choice? And if Sianeho is willing to proceed, then that's what we will be discussing, and then they will brief the legal counsel. And indeed, they were not on a retainer, that you are not doing any other thing. You are only going to be doing this particular work. And on the issue of the Concord, indeed, it's just purely to assist this process, because these matters are interlinked. You might say it's a different process. You don't want to be involved. Unfortunately, the issue of the funds is impacting on your work and the speed of resolving this matter. When the Deputy Public Protector wrote that letter on 1st of March, copying the committee chair, the speaker, and the Justice Portfolio Committee chair, exactly that created chaos for this particular committee. And unfortunately, you cannot say you are not involved in the process. So it's for the court to advise. Unfortunately, there is history. You would say that, yes, there's concord judgments on the matter because, yes, the two matters are relating to my matter before the courts. They said, no, you can proceed. And we know that Parliament, the very same Parliament in the past with the Nkandla matter, you proceeded, you dealt with the matters, and the Concord had to tell you that you shouldn't have handled the way you handled the Nkandla matter. But at any rate, it's for Parliament to continue. And if you say the 4 million is enough, we will proceed, and then the funds will be exhausted again, because I understand, which I don't know how they came to that, the money is including the traveling, the accommodation and everything, and whether that will be sufficient to finalize the matter. I think again is doing one and the same thing and expecting different results. So the issue of Honorable Maneli, that it was a break and the walkout and change and everything, I've explained. Read the letter from the CEO, the accounting officer, and I don't know whether if you read that letter as an accounting officer, possibly if you were an accounting officer in the past and understanding the PFMA, and I think it's high time possibly, you know, as committee members, you engage your counterparts in the committee where the Auditor General sits, so that they can also make sure that we comply to what the principles and the PFMA is requiring of us. Definitely, if you can do that, because you cannot come here and say it's a continuation when there's a letter terminating and saying we can't pay you. How do you continue beyond that? And as I said, I'm not the accounting officer. I don't deal with the resources. There is accounting officers who are dealing with the monies. So the issue of there's no formal letter to withdraw, the letter from the CEO was basically terminating the services of Sianego. So the CEO must go back to the attorney and they need to agree on terms. And that's what should be happening. And indeed, I'm glad that you are proposing the postponement, which I appreciate. And indeed, the whole week we will have to do that and deal with the matter. So the issue that I'm saying that I'm the client and not PPSA. I mean, I don't understand why do you have to go to that Honorable Maneli, because at the end of the day, I don't deal with the resources. Even in the past, there's a CEO, there's legal services. I need an attorney. Yes, this is my attorney of choice per the Constitutional Court judgment. And indeed, I told legal services, this is my attorney of choice. Legal services asked, okay, attorney, who is your counsel PP of choice? Then I indicated, based on the fact that they know this matter from a number of matters they defended, they have a lot of information, with the understanding that at least they will be saving this process a long time. That was the understanding. So if you say, Honorable Maneli, I don't know whether you also practiced and you know that the evidence before this committee justifies the 4 million, I can't comment on that. And remember, my statement has attachments which will still have to be placed before this committee as part of the evidence. And there was no one who agreed to that 4 million. PPSA just indicated that there is this surplus which they can avail. There was never a process in the past where they engaged the attorney, because that's what they did. Sit down with the attorneys and then we agreed on that particular money. So I think it's good for us to go back and do that particular process with PPSA. So Honorable Zungula's issue, yes, I've raised in my response to the chairperson that the issue of the legal aid and the way it was raised, and indeed I didn't expect that from the chairperson, which I clearly stated in my letter that unfortunately even the mandate of the legal aid is totally different to this particular process. And if Minister of Justice, who is overseeing the legal aid, should be accounting to them, is the one who's also assisting the Public Protector South Africa with the additional funding. So, I mean, if there were monies there, surely they would have allowed that the monies would be then moved to the public protector. So the issue of Honorable Sucros, it's concerning for me to hear you speak like as if I placed myself in this situation. And for you as a member of parliament, I'm very much concerned about the monies which were spent. I never brought myself here. You are one of the parties who said there's prima facie matter. There's a panel of the 3 members who were paid by the very same parliament, and yourself as committee members, yourself being present, you agreed to the expansion of the scope. If you stick to what the 3 panel members dealt with, I don't think we would have been here. And I indicated that for those 15 witnesses whom you listened, there was no issue. And it's concerning for me that as a member of parliament, and even myself, I'm concerned, you are only dealing with what has been availed to me to protect or exercise my rights. If I was Busisiwe Mkhwebane from Kwaggafontein, sitting where I'm sitting, I'm not the public protector, because this is within the scope of my work, and it's a new thing which is happening in parliament. It's interesting that you don't even want to know how much has been spent for the evidence leaders, because there's money which has been paid to those 2, it's 1 senior counsel and a junior counsel. So that money as well you should be worried about. So I don't think it's fair for you to just come and think that me insisting on that. And it's the Constitutional Court judgment which said I should be represented. And again, not every Chapter 9 institution head is legally qualified. What Parliament was insisting on, and the Speaker saying, I can defend myself. But then at the end of the day, I think it should be fair, and it should be a situation where, as yourself, this committee, because if you stick to the panel recommendations, we wouldn't be sitting here. But you decided yourself to revert back to the Mazone, Honorable Mazone as motion, which then expanded this whole process. So I think it should be fair to everyone that it's not me or the lawyers who expanded the scope, it's yourself. And when we agreed with the 4.45 million originally, Honorable Dlagute, with the legal team, and the very same agreement, CEO signed with Sianejo, the 4.5 was based on the fact that it will deal with only the panel recommendation, the prima facie issues. But then Uguti, then you decided to go against that. Hence, we are sitting here. I'm also concerned about the monies which were spent, and I think it should be fair to the public as well to be transparent how much is spent for the evidence leaders, because we cannot only speak about this 26 million. We should be speaking about everything which has been, because Parliament wanted to run this process. You then had to engage the services of the 2 council who are not employees of Parliament. So I think it should be a fair process, and again, learning from this process going forward. So the 4.5 was based on the assumption that the process will only follow the panel, 3 panel members. But that people who were not even part, or the panel members recommended that their evidence is not necessary, there's no prima facie case, you decided to invite them for 2 days to sit here and to be listened. So I think it should be very fair, Chairperson, that we go back, we then agree with the public protector and the CEO, the accounting officer. That's why I said in my opening, I don't know how the 4 million was came about, and the attorney should determine with the kind of work remaining and the council, then we can proceed. Definitely we will have to proceed. So Honorable Dlagute, there's a CEO letter, which I think it would be availed for you to, or for committee members to deal with. So Thank you, Chairperson, for allowing me to just clarify these issues for the committee members, and I'll hear from you.
Thank you, Public Protector.